And it is noon, and this is a long amount of material, so I am just going to go ahead and start, and people might continue to pop in, but that's okay. This is Kirsten with ICADVA. I've been here for a very long time. If you are unfamiliar with me, if I have not met you yet, nice to meet you. This is at least one way you can kind of get to know my training style. And hopefully I'll have a chance to have you in trainings or be in trainings with you as a trainee sometime in the future, get a chance to meet you. Today's topic, oh my gosh, confidentiality. As I said, this is going to be a big one, and I'm going to be throwing a lot of just straight up information at you. Hopefully to keep it interesting, I have a few scenarios. So I hope you can access your keyboard somewhat so you can respond. And the first thing that I want to just lay as a ground understanding about confidentiality is that the whole reason that we have it is for the safety of survivors. That is its mission, that is its purpose. And so anything that we do with confidentiality, I think the number one question to ask is, does this contribute to the safety of a survivor or does it not? And as I go through, you'll see points where I feel that perhaps we've fallen away from that goal sometimes, and we need to reorient ourselves. Is this for the safety of a survivor, or is there something else that now confidentiality is being used for, and we really shouldn't be using in this situation? One of the things that happens with confidentiality, there are times we are most likely to break it, and they are not times, and usually it's not about having ill intent. It is rare that somebody violates confidentiality by saying, I'm going to go out and make my client's life hell. Usually it is about things like having overwhelming emotions about a situation and just needing to talk to somebody, and an appropriate person is not there, a coworker, a supervisor, and so you end up sharing it with a friend or somebody who really should not have access to that information. Sometimes it can happen because we frequently have dual relationships with clients. They are members of our communities, so we see them as their fellow parents in PTA meetings or at ball games, or we go to we have the same faith community, or we're at farmers market together. All kinds of situations where we engage with clients outside of just that counseling relationship, so sometimes things can slide that way. And also sometimes we have dual relationships with other agency staff. So maybe I'm really, really, really close to that particular Child Protective Services worker, and I trust him or her, and I share with them information that I wouldn't share otherwise based on our personal relationship, rather than keeping the professional sense of confidentiality in mind. Sometimes we goof up because the opposition, if you will, people causing harm, are often very, very clever. And again, talking about that overwhelming emotion, sometimes we might be triggered ourselves because of a situation we're dealing with, and that could lead to a violation as well. So those are places we need to be on guard. Now with that as a background, let's talk about the actual legal limits and the boundaries that are set for us by external forces. ICADVA has service standards. They were developed by our membership. They are best practice. Here's what we think people should be doing. There's minimum standards, and then there's, and if you have the extra resources, here's what would be really great if you could do this too. And I'm going to use those as a framework to go through this whole realm, through the trees of confidentiality. So this is my map we're going to follow ICADA service standards as our map to go through here. And so we're going to start with that first one, looking at federal and state law. And the standard, I'm not going to be reading to you. That's another reason why I want to send the PowerPoint out, is so that you'll just have this stuff in front of you. But basically the standard says, yeah, you're going to comply with the law. And there are a bunch of them. FIPSI, which is a very strange way of pronouncing FVPSA, FIPSI. And there's the code reference, should you ever need it. It requires that anybody getting grants, and most of your programs do, if not all, getting those grant funds, that you must maintain confidentiality for your client records and the location of your shelter. What you'll notice through here is a lot of the language is old-fashioned, I guess is the word I would use. In other words, the standards were written prior to us changing our service model to be non-shelter-based. The legislation language is certainly written with shelter-based services in mind. So when it says shelter, just think program location, program offices. But in that case, it actually meant shelter, like where people are housed. So if you have an outreach office somewhere and you want people to know, great, let people know. VOCA, and again, there's a long list of numbers that is the reference for that, should you ever need it. Says that you will not reveal identifying information, including in legal proceedings. And then the penalty for that is to lose your funding. There's ESG, Home Emergency Shelter Grants, that many of you get. Reference number there that, again, require confidentiality. And the Violence Against Women Act. There's an expectation there from Congress directly that our programs, if we're getting VAWA money, that we maintain confidentiality. So lots of stuff on the federal level that we can refer back to when we are challenged by our allies in other fields. So here's our first scenario. Sharon spent 5 years working for a domestic abuse program where she was a certified advocate before she moved to a new job at a food pantry. Her first week, because you can't avoid it, you're a magnet wherever you go. Her first week, a food pantry client came and talked with her several times at length about domestic abuse. Now the prosecutor wants Sharon to testify against that client's partner. Sharon refuses on the grounds that she is a certified domestic abuse advocate and has privilege. Okay? So, my question is, hopefully now it's on your screen, does Sharon have to testify? And this is anonymous, like nobody can see what anybody is saying as far as their vote. So if you don't know, just guess. I see that half of you have voted. I'm going to aim for a 75% response rate. 54%, 57%. We are getting closer. 63%. Sharon spent 5 years working for a domestic abuse program where she was a certified advocate. Now she's working in a new job at a food pantry. A food pantry client has talked with her about domestic abuse, and now the prosecutor wants to use her as a witness. Does she have to testify? And we seem stalled out at 69%. That's good enough. So let me close that and share it. So 28% saying, yep, she does have to testify. 44% saying, nope, she still has confidentiality. And 28% saying, well, it's going to depend on if her certification has expired, because the certification is good for 2 years. So if she just left one job and went to the other, she might still be covered by it. Let's hold off on the answer to that and look at Iowa code. So we talked really fast about where in federal legislation we're granted confidentiality. Let's look at what the local Iowa law says. That's in 915.20a. And in order to understand any code, you usually have to break it down and look at the definitions. So this code is about giving victim counselors confidentiality or privilege. And then it defines who a victim counselor is. A victim counselor works at a crime victim center and has that minimum 20 hours of training. And then I didn't list out the topics, but the training that I know that you all have. Okay, well, that's interesting. You work at a crime victim center. Well, what's a crime victim center? Well, it tells us that too. Any office or agency offering assistance to crime victims through crisis intervention, accompaniment to proceedings, and the primary purpose of that center is the rendering of advice, counseling, and assistance to crime victims. So when I look at that, what I would suggest, I'm going to come back here, is Sharon has the 20 hours of training, but with this definition of a crime victim center, she actually doesn't work at a crime victim center anymore. Now she works at a food pantry. So even though she's still certified, her certification hasn't run out yet. Let's assume that. Since she no longer works at a crime victim center, this information that she's received at the food pantry is no longer privileged. Now, if she were to say, you know what, working at the food pantry is not what I want to do. Thank you for telling me I forgot to close down the poll. Here, let me. Hopefully now you can. This is why I can't multitask. Thank you. I really do appreciate it when you say, hey, you didn't push the right button yet. Since she's working at a food pantry, she's not working at her domestic abuse program. She no longer has privilege on the new information she would be getting, right? If she changes her mind and says, food pantry work is not for me, I'm going to go back to doing domestic abuse work, and gets rehired somewhere, and her certification is still current, great. She doesn't have to go through training again. Now she's covered again. She has privilege again, but not while she works at the food pantry. Okay, so now we know who a victim counselor is, where they have to work, but let's talk about what's covered. And what's covered is confidential communication, and the code defines that. Information shared within a counseling relationship. So any emails, any conversations, letters, you name it, any information that's exchanged in the course of the counseling relationship, and that's specific. It does not include things that would not be within the counseling relationship. So if, for example, you had somebody that you had a dual relationship and you learned something about them because they're your neighbor, right? And you knew for a year that there was stuff going on, and then they came to services. The stuff that you knew from being their neighbor the year before that, none of that would be privileged, because that you learned through a different relationship. The actual privilege that the law gives is that you shall not be required or examined in terms of legal proceedings, right? unless the victim waives that privilege. So I have another scenario for you. Tia is 14 years old. She told you about her dad's abuse after you presented at her school. Tia's parents are fighting over custody. Tia's mom waives confidentiality and asks you to testify about what Tia told you. Now let's see how well I do this one. So my question is, do you have to testify about what Tia told you? And so yes, if Tia's parent or guardian waives privilege. Yes, abusers can't waive privilege, but the non-offending parent can. Or no, Tia has confidentiality even though she's a minor. While you're thinking about that, I'll read it one more time. Tia is 14 years old. She told you about her dad's abuse after you presented at her school. Tia's parents are fighting over custody. Tia's mom waives confidentiality and asks you to testify about what Tia told you. And again, don't hesitate to take a guess because no one can see what you voted for anyway. It's all anonymous. Now I've got 69% voted, so. Okay, I'm going to close that down and I'm going to share it. Most of you are saying that no, that Tia has confidentiality even though she's a minor. A couple of you think that mom has waived privilege and therefore you have to testify, and nobody agreed with the one that said yes, you have to testify because abusers can't waive privilege, but the non-offending parents can. And let me hide that. We're done with that one. And the fact is that in Iowa, minors have privilege as well. And there isn't really an age limit attached to that, like, you have to be over the age of 10 to have privilege. It's simply if the minor can understand the idea of privilege, understands what they're waiving, and so that really depends on that particular individual child, and often then it is up to the judge to decide whether or not a particular child has privilege. A 14-year-old, though, pretty good chance that unless there's something unusual going on with that 14-year-old, that they do in fact have privilege. I would assume that they could not that it would be a violation to do that. So I have a question here. For co-located advocates, it's my understanding we're not to let DHS know whether or not a survivor we are working with has accepted services. That's correct. Are we able to let them know if someone has declined services? No. My opinion is no, because it could hurt the survivor's case, but do not know what the since you can't say whether somebody has or hasn't, is or is not in services, you can't say yes or no. I'm sorry, I cannot share any information about that person at this time. Sometimes it's going to be in that client's interest for you to be able to share that, in which case you have to get that waiver from them. This can get really frustrating in situations like, which I'll talk about a little bit further on, but like, let's say there's a missing persons report and the police are calling you and you're worried too, and you want to say, no, we haven't seen her, and you want to be able to answer no, but you can't actually, even in those circumstances. Similarly, again, for co-located, oh, nope, it was the same one. It just posted twice for me. Oh, well. You also can't tell DHS when you have reached out to a particular person. You can tell them what your policy is. When law enforcement lets us know that they have responded to a case, we we have a policy where we reach out to that potential client and let them know what our services are, or when the emergency room calls us, or when DHS makes a referral to us, we reach out, and this is our tip, we call or we send this letter or we show up, whatever it is, this is our practice. But you would have to have a waiver from them to talk about a specific case. The other thing is that DHS knows or should know what our limits of confidentiality are, and they certainly have lots of limits on confidentiality. So it might be a matter of having a clarification conversation separate from a particular case to remind them. It is in all of their manuals, all of their policy manuals, what we can and can't do as far as advocates. If they don't know where our confidentiality boundaries are, there's no excuse for them being ignorant of that. However, things happen, and it may be genuine ignorance or just trying to speed the situation along. But you need a waiver to talk about any particular person. And yes, even when you're getting a referral, even if it's a referral where that person has a legal responsibility to contact you, let's say it's somebody who has to contact you for their probation. Here's what I would say. Let's say somebody's on probation and one of the requirements is that they contact you. If they contact you, you can let them know, hey, your probation officer needs, if this is part of your probation, it would really be helpful if you signed a waiver so I could let your probation officer know that you had in fact followed through with this requirement. And that person is 99.99% sure that they're going to give you that waiver. If you're having a conversation with that probation officer and you say, I can neither confirm or deny that that person has contacted me, that probation officer is 99% sure that in fact they did not contact you. So even when it's a referral and even when there's legal consequences to whether or not you made that contact, you can't disclose without a waiver. Those are great questions, by the way, because it really gets into the nitty-gritty of actual daily practice. Another scenario. So the defense says that the shirt offered by the prosecution as evidence in an assault case does not belong to the victim. The prosecution wants to call you to testify that you saw the victim wearing that shirt when she was brought into the emergency room. Okay. So that one's a little bit simpler. Arguing about a shirt. Did you see that shirt on that victim or not? And do you have to say whether you did or not? Yes or no? Do you have to testify? Most of you have voted. And most of you have voted, and everybody said no. Clear down in 915.20a, and I know people don't go around reading the code because it's really good material to make you fall asleep. There is actually a couple of exceptions. So this may surprise you, but one of the exceptions is you would be required to testify if there's a matter of proof concerning chain of custody of evidence. So photos, clothing, etc. I don't know. I have never heard of this ever happening, and it would be a pretty poor case, and there would be a lot of other things that are going wrong with this case if the prosecutor is having to rely on you to prove a chain of custody of evidence. Nevertheless, it is in there that this is one of the little carve-outs where you could, in fact, be required to testify under Iowa law. So you'd say, yeah, on Tuesday at 8 p.m., I saw this particular person wearing that particular shirt. The other carve-out is a little bit more disconcerting to me, and that is physical appearance of the victim at the time that you first had contact. So it's weird because you couldn't talk about what they said to you, but you could be required to talk about what they looked like. Like, were they crying? Did they have a bruise on their throat at the time of that assault, or at the time that you first had contact with them after that assault? Again, I don't know any time that this has ever been used, but it is actually there tucked away in the code as an exception. It's an odd exception. It would be a very hard thing to navigate where the line was between what was physical appearance versus anything else that you learned about them. No one seems to know it's there, so it's never come up, but it exists. Couple other things that the Iowa Code says around confidentiality. One, if you have reason to believe that the person lied on the stand, and one of the sides is offering to the court the fact that they lied. So the fact their lie has become a part of the case, has become an issue in the case, and they're trying to prove that they're lying, and you know that they're lying, then they could force you to testify. The question for me is, how are they going to know whether you know or have strong reason to believe that the person lied or not? And they're not going to know that. So again, this is in there, but I've never heard it used, and I really don't know how it could be used, because they would have to magically know what you knew or thought you knew, and what your reasons were for that. And then there's a process of getting to all of that, and I have it in the PowerPoint. They have to have a written note. They have to put in a written motion. They can't just bring it up in the middle of a hearing and say, but the advocate knows that they lied, and so now I'm going to call the advocate to the stand. That's not how it works. And the information that they're seeking has to be relevant and material to a criminal act. So none of this actually applies to a civil case. So none of this applies to custody or divorce. And having you testify has to be more important than any harmful effect on breaking confidentiality on that victim. So those are all in there as part of the code. Wow, who knew that? But it hasn't been challenged. Doesn't mean it couldn't be used in the future, but so far nobody's done that. So along with the question of what's the purpose of confidentiality, I think it's also important, particularly when we think about what we share and when and why, and what we don't, to ask ourselves who owns confidentiality. And and it's helpful to me when I'm navigating these things, is to think of confidentiality as actually being something that is owned by the client. It might control what I do, but the client owns it, and the client holds the key to using it, to not using it, to waiving it, to not waiving it. It is their belonging for their purposes, for their safety. That brings us to our next scenario. Elena is at the door with several laundry baskets of clothes and other items. As you help her take them to her room, you say, "How on earth did you manage all this stuff on a bus by yourself?" Obviously, this is a shelter-based question. She says that she called her cousin for a ride to run errands and drop her off at the shelter with her stuff. So my question is, has Elena violated confidentiality by telling her cousin where the shelter is and having her drop her off? So has Elena violated confidentiality? No, she doesn't have to keep confidentiality, or yes, she signed a non-disclosure agreement, she has violated confidentiality. I have 53% voted. Okay, now most of you voted. So a quarter of you saying no, Elena doesn't have to keep confidentiality, and about 3/4 of you saying yes, Elena does have to. She signed a non-disclosure agreement. And I'm sorry to tell this to the majority of you. In fact, if you think about everything that we've covered, state law, the federal requirements, there's not a single one of those that address the survivor. In other words, they are all requirements for us to maintain confidentiality. There is absolutely no legal requirement on a survivor to maintain any kind of confidentiality. And having somebody sign a non-disclosure agreement might be a way to encourage for the well-being of the whole community, whether it's a support group community or a shelter community, whatever. Like, hey, what we say here stays here, and who you see here, that's private. There's absolutely no legal stance to that, and a non-disclosure agreement is not actually any kind of a legally valid contract because it's coercive in nature. In other words, if they say, no, I'm not going to sign that, you still have to provide services, and they have the right to refuse to sign that, and to require them to sign it in order to be safe and get services that are about domestic abuse is a form of coercion, and coerced contracts have no legal standing. So when we look at trying to balance safety and confidentiality, and remember that it is the survivors that own it, putting a contract that is not valid. As it said, it's not going to change what they do, and if they do violate it, then you're in the situation of asking yourself, okay, if somebody's violated this contract, what are we going to do for them? What's the penalty? And there really isn't a valid penalty, because again, if you say, well, we're going to throw you out, we're not going to provide you services, then they were coerced into signing it. Does that make sense? They either sign it and agree with it, or else they don't. That means it's coerced. It's not valid. It isn't actually a contract in any way, shape, or form. Similarly, saying, well, for confidentiality reasons, we don't want you to have contact with the abuser. I don't know of any programs that do that anymore. It is something that used to be pretty common, but we all know there's tons and tons and tons of reasons why people maintain relationships with the person doing harm, and one of the big ones is safety. So they were stuck between this rock and a hard place of, I want safety by accessing these services, but I also need to have the safety of being able to de-escalate my partner. I need to be able to get a hold of them about the kids, or you name it. My economic survival is tied to them. So that was not a good balance between safety and confidentiality to prohibit that contact. And sometimes if the batterer found out where those services were being provided from, then saying, well, I'm sorry, you told them we can't serve you anymore. Again, that's putting the onus of confidentiality on the person who is the most vulnerable and who needs to be able to make decisions, and often life-threatening, life-saving decisions about confidentiality without worrying about how we are going to regard them or whether or not we are going to continue to provide services to them. When the person doing harm is threatening you, you need to be able to de-escalate them. And if that means I'm going to tell them where I'm staying, or I'm going to tell them where that office is, or you name it, then I need to be able to tell them, because in that moment, I need to stay safe. And we of all people should understand that. So this is a really difficult balance, but what I would suggest to you is legally, Elena has not violated confidentiality because she's not required to keep confidentiality, and we need to pay attention to where we put that balance between safety and confidentiality. Confidentiality should be a pain in our butt. It should never be a pain in the client's butt. And in fact, one of our service standards addresses this specifically. You can't take away services if somebody discloses location. You may have to adapt services. So, for example, maybe they're not staying. Like, okay, your partner now knows that you were staying here, so maybe we'll have to move you over here because it's no longer safe for you to be here. Great, but you can't. They can't face any kind of penalty for sharing that. Okay, zipping right along. This is another shelter-based one, and this is just that if you do in fact know that there are people that are going to be coming to a shelter, that you, whenever it's possible, that you let the residents know. So, hey, the bug guy is going to be coming on Tuesday at noon. Hey, the child welfare person is coming to do an interview such and such time, so that they can make decisions over whether they want to be home, whether they want to be in their room, you name it. Sometimes you can give that kind of reasonable notice, and sometimes you can't. And sometimes having visitors in is an inevitability, like the bug guy. And so you just have to navigate the best you can. Okay, now there's a whole set of standards that are lumped under administrative issues, and I'll give you an example. Here's another scenario. Eduardo, in quotes, because that's not his real name, Eduardo doesn't want to give you his real name. The name of the person doing harm, what town he lives in. He just wants health safety planning, a place to sleep overnight, and money for food. Okay? So my question is, does Eduardo have to give a real name? And the choices there are yes, for financial assistance he does, no, never has to provide identifying. Yes, he does, but we do keep it confidential and we're not like sharing names and stuff with funders. So while you're answering that, this is a good time for me to answer a chat question. If the abuser shows up continuously at the program and the staff is uncomfortable, steps that you can take. Remember that while your clients, while survivors have confidentiality, people causing harm don't. So one thing I would want to do, if it was possible, I would want to ask that survivor what action they would feel comfortable with, or to say we're thinking about doing this, this, or this. Which one of these things would you be most comfortable with? You can ask the person to leave. This could be considered trespassing if you've asked them to leave. It's private property, I'm assuming. You've asked them to leave, they're not there. You can go so as far as getting a restraining order. You could ask them to leave. You could ask the law enforcement that you are friends with to go around and have a conversation with them, an informal one of, hey, look, I've dealt with these people. I've dealt with with this agency for a while. You don't want to mess with these people. You don't need that kind of trouble. So just lay off, leave them alone. We got our eyes on you, and you don't just friend to friend, buddy to buddy. Let me tell you, knock it off. That informal stuff. The more formal, you could have your agency attorney send a cease and desist letter. There are a number of steps you can take that you could take without acknowledging that you are, in fact, serving their partner. But in any case, I would, if it's possible, I would ask the partner what they wanted, or present what are more of your options of what you have decided you're going to try to that person, and which one of these three things, at the very least, let them know that you are in fact going to be doing something, because the retaliation may be against them and not against you or your agency. So they need, at the minimum, a heads up that you are sending cops around to have a conversation, or your attorney sending a letter, or whatever it is, that steps that you've taken. But the people doing harm, there's no duty of confidentiality to them. And sometimes somebody may come to you assuming that you are working with their partner, and you're not. Just that simple. Never heard of that person, don't know what you're talking about, but you need to get off of our property. Okay, so the question about serving Eduardo. Close that out and share it. Does Eduardo have to give a real name? Most of you think that nope, there's never has to provide identifying information. And then some of you think yes, but because you do keep it confidential. and then somebody saying yes for financial assistance, like could be confidential, doesn't need it for other things, but yes for financial assistance. And let's kind of go through our standards to answer that one. Standard says you have to have a written policy around your confidentiality. Okay, blah, blah, blah. That one's boring. You can read that on your own. This one's a little bit more important towards that scenario, in that you're letting folks know exactly what kind of information you need and how it's going to be used. And the standard says that they're not obligated to provide any identifying information about themselves or that person doing harm to receive services. They can refuse any and all parts of services to protect their anonymity. I can remember a time where somebody came in and I absolutely knew that they weren't who they were saying they were, because I had gone to elementary school with them. And thanks for catching me. I'm not sharing. So I knew who they were, and they knew that I knew who they were, and they were insisting that they were somebody else. But it was like, okay, we're just going to roll with it. I'm not even going to say that we both know that we're lying here. It was irrelevant. It was really irrelevant. They simply needed the services. So, yeah, Eduardo doesn't have to give a real name. More standards, you need to keep your files, whether they're electronic files or paper, they need to be secured, they need to be locked. And if you need help with figuring out electronic security, Scott here is your guy, and I know that he's been to a number of programs to talk about cloud storage and access and all of those things. He's your person that can help with that. Clients have the right to review or request a copy of their file at any time, or any other personal information you are gathering about them. So if you have any notes or like anything that you record, that client has a right to see. So keep that in mind anytime you are writing something down. They can add stuff to their file. Let's say, I can remember people saying, well, here's pictures and I can't keep them at home, but if you can keep them for me, okay, we'll put them in a client file for you. Here's a copy of that child protective report. Here's a copy of my restraining order. All kinds of things that they might want kept safely. That was something we could do. We could put it in their file. There are other things that often go in files, right? Since their file should hopefully be about aiding them in their safety. They're also there for funding requirements, that we have something that shows that we are doing some work. And the liability issue is, if you say that you have a signed release, have a signed release and have it where it is available. Should a question arise about it, you have it. You can produce it at will. The files for the funding requirement of our information is that it's kept a minimum of 4 years. But if you can hold on to things, particularly things that are have legal ramifications or emotional, like, oh, look, this person brought pictures of their injuries, but also here's pictures of their child's birth. Am I going to destroy those? If I can hold on to them, if I have space for storage, it'd be a good thing to hold on to those. That may be the only source that they have of those pictures. So let's see. I'm not very good at closing poll results. I'm like a dog. You're going to have to train me numerous times. Client versus. One trick of the trade, if you will, that has been suggested from attorneys dealing with confidentiality issues from around the country is that it might be useful in some circumstances to have client files. These are our official client files called client files. And that's where we have the restraining orders. That's where we have, the intake, the administrative kind of stuff, right? And then we have client property. So maybe a client has a file that has the birth certificates and the photos and everything else. But that's not your agency client files. That's their personal client property in a file. Or you have administrative files, separately labeled administrative files that might be about stuff. Let's say that a client is fighting with another client and has there's been a physical assault client to client, and there's some kind of paperwork in regards to that. Maybe that goes in an administrative file. And the reason for that is that when somebody subpoenas records for a case, there's a good chance that it will say, domestic abuse program shall provide client file, regarding blah, blah, blah. And so you provide the client file, but you're not providing the client property or the administrative paperwork, right? It may be that the subpoena says client file and all other written information regarding that client, in which case this wouldn't work. But as I said, a little trick of the trade I thought I'd throw out there. I kind of blabbed over what's in the client file. Let's go for another scenario. So Carolyn has been your client for 3 months, and now she's moving to Ohio. She wants to take her client file, and she wants you to get rid of any evidence that she was ever a client. So delete your emails, any documentation she has. She wants it gone. She is disappearing. She wants nobody to know she had any contact with you. So, do you eliminate the records of your advocacy? And your choices are: I give her the case file, I destroy the emails, I keep it for 4 years, or I give her a copy of the case file and delete the emails. %43 voted. We are almost at our hour time, and I was stupid to think this would only take an hour. So I'm just going to keep going, and I apologize if some people have to leave before we're done. But it's probably at least another 20 minutes of stuff here, and I'm just going to keep going. %49 voted. Either people aren't sure, or this just is not as interesting a question as the other one. I'm going to close it out. Okay, so we have most of you saying you're keeping it for 4 years because that's the funding requirement. About a third saying you're giving her the case file and destroying everything, and 17% saying you'll destroy everything except she gets a copy of the case file, and then I'm assuming you're keeping the original. So I'm going to hide those. I'm going to share those results. All right. And then I'm going to hide them. I'm actually going to do it this time and say, well, actually, the standard says the client files, yes, shall be kept for a minimum of 4 years, so you can keep them longer. But if clients want to eliminate all traces, they get to eliminate all traces. And if that means that you can't record that Carolyn was your client, my answer is, boy, if you need that one client, Carolyn, to support your numbers for CVAD, you got some bigger problems. I don't think there's a single program in this state who isn't serving far more clients than their funding allows at this point anyway. So to have 1 or 2 a year that just want to disappear is okay if there's no documentation left that you served them. We have some anonymous data on them, and so anything that is identifying, it can go. In this day and age, you need to have some kind of an email policy, and we consider email to be the same as if somebody had called you on the phone. It establishes a counseling relationship, so your program should figure out what you're going to do with that written trace of your connection to them. Databases. There's a standard on databases. We have a new database. It meets our requirements and federal requirements about collecting information. And again, if there's some other database that you're taking part of, folks need to know what data is collected, where it's going, why, and they have to be able to opt out of providing information into that database. This is a real quickie. Yes, if somebody is murdered, you can in fact provide information to the Iowa Domestic Abuse Death Review Team about serving them. That it's the Iowa Code has a place there for releasing that information to them. The Death Review Team, it's confidential what they get. Their stuff is destroyed. So if in the unfortunate circumstance that you have somebody who has been a client that was murdered, you can give the information with the Death Review to the Death Review Team. Similar scenario then, a client dies, the cause of death is up in the air, right? You've been watching the news and you know that the news doesn't have it right. You believe that it was an ex-partner that killed this person. And in fact, you may have really critical information as the last place that she went or talked to. So can you disclose what you know? And if so, to whom? Oh, seriously? I didn't create a thing for that. Shoot. Okay, well, let's just go ahead and answer this one because I didn't create a poll for it. And the answer is, if somebody is killed in those circumstances, you may choose to disclose. You would disclose it to the county attorney that the person was a client. Best practice is that you have permission of a family member. um, you know, their parents or their sibling or whoever is that you're engaged with in the case, or that you get a hold of and say, we have this information, they were a client, would it be all right if we shared that information with the prosecutor? What you cannot do is share that information with the press, but I'm assuming you would know that. I have a whole section that's called client-initiated disclosures. This is when a client wants you to share information. All right? And you probably have a lot of day-to-day practice with this, where you're asking yourself, okay, why is it being shared? What's the purpose? What's going to be the impact? How can I frame this in the most positive light? How can I use this information in a way that's most helpful for the survivor? Our standards kind of mirror what is required for a release to be a valid legal release. It has to be specific about what information. You can't just say, Kirsten has the right to disclose anything she chooses, to disclose whatever information about Sally Jane to whomever. It has to be specific. It has to have a date that it's signed, what the reason for the disclosure is, who the disclosure is being made to. Again, it can't just say, Kirsten can disclose to anybody she thinks would be helpful to know about Sally Jane. And then, of course, signatures. It needs to have an expiration date. Usually it's 30 days, and the person can rescind that release at any time. So Amelia has a hearing coming up that could terminate her parental rights, and she wants you, her advocate, to testify on her behalf. Okay. That one's a bit more straight up. Amelia wants you to testify. So, yes, I will need a release. I can't testify because I have privilege. Or, yes, after I talk with her attorney about any potential conflicts or concerns. Got 43% voting. This was a little awkward for me to come up with this poll, just because I'm only allowed so many letters, and I couldn't fit everything I wanted in one line, right? I'm going to go ahead and close that one. This was a bit more distributed than the past ones have been, right? Amongst the, yeah, I'll need a release, I can't testify because I have privilege, and yeah, after I talk with the attorney. And I would expect that, because, as I said, this one's a little awkward, because, yeah, absolutely you need a release, and yeah, actually you probably should talk to that attorney. So my best answer is one that isn't even up there, which is, yeah, talk to the attorney about your concerns, or talk with the client about your concerns, talk with the attorney about your concerns, and absolutely have a release. What you cannot do is just flat up say, nope, I can't do it because I have privilege. In fact, there's a standard that says if a client wants you to do so, and even if you've said, hey, I don't think this is a good idea, here's all the things that I'm worried about, and it is against your judgment to be testifying, if a client wants you to do it and they have signed a waiver, you got to do it. This is one of those places where I think confidentiality has been spun around, where it is uncomfortable and scary to testify. I get that. It is testifying is still the thing that I am that is hardest for me, and I've done it a number of times, many times. And it is still the place where I still have, stomach upset and worried and all that stuff. But if the client wants it, even if you don't think it's a good idea, we are relying on their choices and their decision making. So you get that waiver and you do it. So then so that's kind of what happens if the client wants you to disclose. Here's what happens when the disclosure is coming from you as an agency. And we let people know. I'm a little late behind, but I'm sharing results, and now I'm hiding them. There are places where we do tell people that we may not be able to keep their confidentiality. So, it's only honest to say we might make, in certain situations, a child abuse report. We might, if somebody is passed out on the floor, we might call an ambulance. There are certain cases where we might violate confidentiality, and it's ethical for us to let that person know. The matters of proof thing that is there in the code is one of those places. The missing person welfare check thing gets a little hairy sometimes. I think an ounce of prevention is the best thing. So when you have an advocacy relationship with somebody and things are very tentative for them, say, hey, so we made an appointment for Thursday, and sometimes I like to have a backup plan if somebody doesn't show up. Like, should I be worried? Should I just assume that transportation or childcare fell through? What would you want me to do if you don't show up, or if you turn up missing? Do you want me to contact anybody? Do you want me to contact your family? Do you want me to call the police? That's a good conversation preventatively to have beforehand if you have the opportunity. There are times once in a while, when you are very, very, very concerned about somebody's welfare. Perhaps you have had word that they are being held captive in their home. Certainly have had that happen. And you might make a decision, not on your own, but as a reasoned decision with fellow staff people, that you are going to do some kind of welfare check on them. It might be, again, depending on the situation, it could be one of your staff making a welfare check. It could be calling law enforcement and asking them to go by and making a welfare check. Sometimes it's a gray area. I can't give you specifics, but to say, this is one of those places where we may not maintain confidentiality. If you're really pretty certain that somebody is being held captive in their home, you might call the police. Similarly, if you have a duty to warn, if there's immediate probable threat, I am going to go over there and I'm going to shoot my partner. And the person has a plan and they have a firearm and they're in their car and they mean it. You have a duty to warn. So that would be calling law enforcement and saying, hey, this is what's happening, and then let them intervene. You may have somebody who is suicidal, and they may even have already attempted something, and they may be bleeding, they may have taken an overdose, and you may be violating confidentiality to get them to the emergency room. Where you have to be careful about shelter or agency-based disclosures is in transfers. In other words, you've made arrangements for them to go to someplace in Arizona, and you're going to help them get there, and you've been in contact with the advocates there to receive them. You need a waiver to be talking with that other program, and you can't just say, hey, this person is a shelter hopper and they're coming your way. This is one of those things where you could only violate confidentiality if you had very reasonable person-based knowledge that you had a duty to warn, right? Like the person is leaving our program because they set our building on fire, and now they are going to XYZ program, and they have a habit of this behavior. We need to let them know that they need to be aware that they set our shelter on fire. There's a duty to warn there in some circumstances. Legal system disclosures. Your program should have policies to deal with if you are subpoenaed, if you get court orders of whatever kind, how you're going to deal with them, all right? What I would tell you is that you shouldn't accept subpoenas and warrants and commitment papers or child custody papers or anything else on behalf of any of your clients, because accepting service of any of those documents is revealing that they are in fact a client. So what you should do is refuse to accept service, and then let your client know that that legal document is floating out there, that there is a deputy or a process server looking for them, and talk with them about the ramifications of trying to avoid service. It's usually not a good idea to avoid service. Just, deal with it. You'll be there for them. Okay, somebody's got an arrest warrant. Let's go down to the police station. Turn yourself in. I will come with you. I will be there while you're booked. I will visit you. We will work on, whatever you need. That's not going to end our advocacy, but the legal ramifications of trying to continue to avoid that are probably going to be more severe on that client. So it's in their best interest to just deal with it. But you don't accept service. Okay. So there's a lot of stuff about this. I touched a little bit on missing persons reports earlier. And so sometimes that person doing harm figures, why should they go to the trouble of hiring a private investigator when they can just make a missing person report and make law enforcement do that? Well, I would tell you in step one, law enforcement many times will not accept a missing person reports on adults because adults are just adults and they can leave and disappear if they want to. But once in a while they will, right? Or once in a while they will make unofficial inquiries, shall we say. If they contact you, they should be making an effort to keep your information confidential. If your client wants to let the law enforcement know, hey, I'm safe, I'm wherever, I'm living with my cousin, or I'm working with the program, whatever, they can certainly waive privilege and channel that information back to law enforcement. Law enforcement cannot promise to not disclose that information to the person doing harm because it may be part of a criminal case, in which case law enforcement records would they would get that. The defense attorney would get that. So your client can disclose if there's a missing person report on them. They don't have to. It might be a good way to make law enforcement leave them alone, make the situation go away, but it also opens them up to having that information shared in court if a court case comes out of it. Let's say you have concerns about somebody. You can always say, I'm sorry, I can't confirm or deny that I know anything about that person. I hope you continue your search. Or, which means informally, please continue your search. Or you can, again, decide maybe this is one of those places where you are taking a decision, and it might be a violation of confidentiality, and it may not even technically be legal, right? Where your concerns override those things, your ethics around this, and you say, yeah, we've got concerns, and here's what we last know of where they were going with that person who is harming them, and, please make sure they're okay. Another scenario. Police are at your office door. They have an arrest warrant for one of your clients. They believe that she's at your program. They want to search the premises to find her. So, you let the police in to conduct the search. And your choices are no, confidentiality prevents me from letting them in, or yes, because they have the warrant, the arrest warrant. So it really comes down to, does that arrest warrant give them permission to enter your premises? And I promise we are getting close to the end here. We have 47% voted, and it is a 50-50 split. Last call. Now, I'm going to close it because I like that 50-50 split. What I would suggest is that you need to read that warrant really carefully, because an arrest warrant is different than a search warrant, and they actually have to have a search warrant to enter your premises to find them. And chances are, if they have just an arrest warrant, and it's probably what they have, just an arrest warrant, then you don't have to let them in. It's one thing to say we have probable cause that this person committed a crime, and so we need a warrant to arrest them. It's an entirely different thing for them to go to a judge and say, we have reason to believe that this person is at this location, and so we need to be able to search that location to get them. So they're two separate kinds of warrants, and the answer is yes, they have to have a search warrant in order to be let in to search. And I would say that whether that person is working with you or not, and whether they're on the premises or not. In other words, if they come in and they're searching the premises, they might find confidential information about other people. So it's not just worrying about the confidentiality of that particular person that they're looking for. It's about the confidentiality of anybody else. One thing also, though, to keep in mind is if they do have a search warrant and they're looking for something, it will specify what they are looking for. So if they're looking for a human, they can only look for places where a human could hide. They can't be going through your desk drawers unless they're looking for a really tiny human, okay? So there still are limits in terms of what a search warrant provides. If it says they're looking for that person or any evidence that that person is a client, then they could go through your desk drawers. Um, so let's say that you've told them the bad news, they can't come in. They say okay, and then they just park right outside of your program, and they are not leaving until your client leaves, because they're just simply going to scoop them up when they walk out the door. They can do that. They have no problem with that. That is within their realm. Again, it's more helpful to your client to surrender voluntarily, to go and turn themselves in at the station, whatever, than to continue to try and evade a search warrant. Great question here. If they have an arrest warrant, do you have to disclose the client resides at the shelter? No, you do not have to disclose that. You can either confirm or deny that you know anything about that person. It becomes a little bit stickier, and this is why this is an interesting question. It becomes a little bit stickier if they have a search warrant and they're inside your program and they are, hang on, I think I have, yeah, and they're looking for a particular person and they say, is this Sally? Like, you don't have to tell them whether or not you're working with them, if they have an arrest warrant, or yeah, she's one of our clients. But if they have a search warrant and they've got somebody and they're like, is this Sally? And you refuse to identify them, that's completely unresolved. It's complete gray area. Try it and maybe we'll find out, right? Like, you could be the advocate that goes to jail and goes to court over this, and we'll get it settled. Always pack your toothbrush when you go to work. Let's see. In emergency situations, they don't have to have a search warrant or arrest warrant. So if they can say, we believe that it was an emergency, that there was somebody in danger in your office at that moment, they can enter without, that's so that they don't have to like get a search warrant if there's a fire or there's somebody who's being held captive. Emergencies override the issues around private property and whether or not they can enter. If they are searching, they can handcuff anybody that's present while they're doing that for, quote, safety reasons, including you. If there's anything that is in plain sight, they can seize it. If there's evidence out, a client file out, if you have a firearm laying on your desk, they could seize that. The chances are you don't have a firearm on your desk. If you know that this is coming, and if you have a really good relationship with your local law enforcement, you may know that this is coming. You can request that you have an attorney present during the search. You can have somebody walk around with the officers while they are doing the search. You can take photos. You can use your cell phone and take video of the search. There are ways to make a record or have some kind of protection during that search. Okay, I already said don't take subpoenas, don't take commitment orders, don't take child custody orders on somebody else's behalf. So I think we're to our last scenario. We are. A member of your support group just told you privately that her abusive husband did not die from a heart attack 3 years ago, like everyone thinks. She secretly poisoned him and got away with it. Do you need to make a police report? This would be a real situation. Yeah, this would be a real situation. So, do you need to make a police report? This is the last one. You've come all this way. I know you can hang in there. I promise we'll be wrapped up by 1:30. I've got a 60-40 split right now. Now it's a 50-50 split. Okay, we're in the home stretch, so I'm just going to move right along. And what I would say is, if somebody discloses that they have been involved in criminal activity, it's confidential unless there's an ongoing threat. So this is the difference between saying, I murdered my husband, or I am going to murder my husband. It's confidential if there's no ongoing threat. So this happened to me, and no one ever found out. And as far as I know, no one to this day has found out what happened. And I kind of think in this particular situation, no one really cared what happened. Now, this was kind of answered already because somebody asked about, if you've got somebody that is coming around and harassing staff, hanging out on the property, maybe even, slashing car tires, that's not an infrequent thing, making terrible phone calls, you name it. Crimes that occur against the staff or program, it's at your discretion whether you report. And as I said, you can do the cease and desist, you can have the informal police intervention, you can have formal police intervention. It is at your discretion, but I would be cautious about impact on clients. I would focus on serious violent crime. Yeah, you don't need to report nonviolent or minor violent crimes such as simple assault. So if somebody slaps somebody during support group, you have no burden to report that. I would seriously consider the impact. See if there are other ways that could be mediated out. Do some more restorative justice kinds of solutions. It may be that you have a client who goes and makes a formal criminal complaint, like you have two clients staying in a shelter and one of them goes to the police and reports that the other one has meth or something. The police still can't enter the shelter unless it's an emergency, even though one client reported that the other one had illegal drugs on them. Okay. Again, I would encourage using more restorative justice kinds of solutions in that situation. If you have a client who has physically assaulted another client, you would continue to offer services around the reason that they came to both of them, but then you may also need to be doing some advocacy for the one who was victimized around what repairing that harm looks like for them. If it means that they want to call the police, then okay, what do we need to assist you with that without you directly calling the police or providing the police any information? This I realize is really gray. Essentially what you're doing is you're going to assist that person in them being the agent that is doing stuff and providing information without you being the reporter or providing the information to law enforcement. And again, anything you can do as far as bringing in a mediator or having staff mediate, focus on repairing harm is probably going to be a better way to go with those low-level kinds of misdemeanor nonviolent crimes. so and so stole my whatever. Um, it's probably something that, if possible, could best be handled in house. And oops, I'm on my last one, and a hand just went up and then it went down again. So I don't know if that was a mistake or not. Are there any comments or questions? You did a great job of asking questions. You did a great job of keeping me on track with trying to navigate the polls while I was talking, and I appreciate that. This is a very convoluted area. It isn't always what you might think it is, and um, sometimes you have to talk through and think, what is the ethical thing versus what is the legal thing versus what is the safe thing, and then try and figure out a best path from sometimes not always good options. Okie doke. Well, thank you. So I hope you have a good rest of the week. And I will get this uploaded onto YouTube as soon as possible.